Ready? Exercise number 91, legal matter. Start. Even if the respondent had continued in the same department, it would not have been possible for him to take the custody of the documents as he would no longer be in charge of the office. Furthermore, it is evident from the letter dated 19/11/2003 that the documents had to be collected from different offices and made available to the respondent. This fact is so mentioned in the letter of the executive engineer. In such circumstances, we are unable to accept the submission of the learned counsel for the appellants that it was possible for the respondent to make an effective representation against the charge sheet. The last payment of the tender has been paid by the then executive engineer Sri Akash Deep Sonkar, and accordingly payment of rupees 19,000 was to be paid by check. Thereafter you have made this payment through check. At page 138 of the cash book, part 73, entry number illegible has been made. You have deliberately made a forced entry in order to cause loss to the government and had made the payment twice through voucher number 142 for the amount 1,93,000 which has been changed to 1,34,000. Therefore, the payment of rupees 59,000 which has already been made shown to be not paid in the aforesaid entry. Full stop. Next para. In this manner, you have deliberately caused loss to the government by the fraudulent act conspiring for the same, and had recovered rupees 59,000 from the contractor through voucher number 141. Reason for which has been mentioned that rupees 59,000 has been deducted due to excess payment made for the work at Saloon, Jagatpur Road through voucher number 142. Now here in voucher number 142 dated, it is mentioned that due to what reason deduction has been made after the issuing of check regarding the amount to be paid, which shows bad intention on your part. You have made wrong entries regarding deduction mentioned in the voucher amount, which is proved to be violation of Financial Handbook section 5 under bracket part 1 bracket out para 4D and 83. Voucher number 141 proves that the divisional accounts officer has issued the check regarding the aforesaid payment passed by the assistant engineer. At the time of issuing check, deduction of rupees 59,000 from the amount to be paid makes your conduct suspicious, and you are found responsible for the misconduct in this regard. Therefore, you are found guilty of misconduct according to para 3 UP Government Servant Conduct Rules 1956. Therefore, the check has been wrongly encashed by you after making fraud entry by self-name, and the amount has not been taken in cash book. Stop. Next para. The firm has alleged that you had received payment after committing fraud. Therefore, you are found guilty and misconduct regarding the misappropriation of amount of rupees 1,29,000 after committing fraud on the documents and violating the financial rules. You are also held guilty for misconduct according to Para 3 UP Government Servant Conduct Rules 1956. Stop. Next para. Case number 37/98 has been instituted for adjudication between Miss Indian Coal Suppliers versus Government of UP. The case has been decided according to which demand for rupees 26 lakh along with interest has been made by the concerned firm from the department. The fact has been in your knowledge that the option of appeal in the aforesaid case has been rejected by the government. In such situation, you had not prepared the defense regarding validity of the agreement during framing of issues in proper manner. The case has been dismissed only on the ground of deficient court fees. You have deliberately appointed a special advocate without permission of government, had not paid court fees and had colluded with Miss Indian Coal Suppliers to cause loss of rupees 26 lakh to the government by presenting weak case before the court in order to cause benefit to the contractor. A bare perusal of the aforesaid charge sheets shows that the three charges were based on official documents or official communications. We have earlier noticed the relentless efforts made by the respondent to secure copies of the documents, which was sought to be relied upon to prove the charges. These were denied by the department in flagrant disregard of the mandate of Rule 7, Sub Rule 5. Therefore, the inquiry proceedings are clearly vitiated, having been held in breach of the mandatory Sub Rule 5 of Rule 7 of the 1999 rules. Stop. Next para. The first inquiry report is vitiated also on the ground that the inquiry officers failed to fix any date for the appearance of the respondent to answer the charges. In such a case, the inquiry officer shall record the statement of witnesses mentioned above. Full stop. Thank you very much. Guys, today again I am requesting, please always try to repeat the matter so that your fluency and accuracy on steno will improve. And also there is one more humble request, please subscribe the channel so that you can get the first notification on legal and general matter. Thank you very much.